How to represent yourself in Arizona Family Court. Step 1. Figure out your goals and objectives. Today we're going to be mostly focused on the process, which is long and not really easy. Let's start at the beginning. The beginning is before you file or before you're served. If you know that you are going to be facing a family law issue, because you're either facing a divorce or you've had a child out of wedlock, before you go to the courthouse, there's some things that you should do. We should determine what your objectives are, what is most important to you. This means really thinking about what your life is going to look like in 3 years. How do you see a custody arrangement working out? How do you see a parenting plan working for you and your children? And everyone can still hear me, right? There are some people who are saying they can't. Oh, yeah, people are saying they can. Okay, fabulous. So, we're going to look at what are the main issues. Do you want to stay in your own house? Do you want to continue being a mostly stay-at-home parent? Are you looking for financial security? What are your most important objectives and your biggest fears? Step 2. Figure out your resources and budget. The next thing that I'm going to ask you to do, after you really think about what your life looks like here in the next 3 years, 2 years, 1 year, is to gather your resources. The process of going through a family law case is long and hard. It's a marathon, it's not a sprint. I'm going to ask you to really gather your resources, both emotional and financial, so that you can make the best determinations about how to achieve your objectives and set the correct expectation. How do you anticipate the opposing party will respond? Is it possible for the two of you to work together to come up with some solutions that work for you? Because the bottom line is, as a family, if you're not in a family court system, you decide how your family is going to operate. You can continue to have that only if you and the opposing party can agree on how your family will continue to operate after your breakup or your divorce. If that's not the case, if you're not able to come to an agreement, then the statutes and rules apply and they will determine how your family is going to run. It's usually not the best position for people to be in, so if there is any way for you and your opposing party to work it out, usually that's a better outcome for you and your children, not always, not always. By considering these issues in advance, you can better come up with and execute a strategy. You don't want to go into a family court case without a strategy, without knowing what it is that you're hoping to achieve. Otherwise, you can't really measure success, and we have so many different tools available to us, both as self-representing litigants and as attorneys, to figure out how we're going to move forward that in advance. Before we file anything, we want to come up with and execute a strategy. One of the first decisions you need to make is whether or not hire an attorney. You may or may not know this, but between 80 and 90% of people in family court represent themselves. You are the majority. You are the vast majority, in fact it's not even close. So with that being said, there are too few resources that are really geared towards meeting your needs, empowering you and making sure that these life-changing events are handled in the best possible way. Most people are happier if they hire an attorney, but the fact of the matter is that that's not true for everyone, and there are various reasons why people choose not to hire an attorney. Money is the primary reason, but also people may think that they can handle it on their own or may think that it's not a good use of their funds. And I think it's really important for you to do that analysis to determine if you have the funds. Is it a good use of your funds, and is it a good use of your funds to hire that attorney right now? Or is it a better use of your funds to map out a strategy and figure out when and if you need that attorney most, and wait to hire the attorney until you need them? Usually and sometimes that's a better idea for people, and that's what limited scope services are. Under a full scope model, you go in, you retain the attorney is your attorney of record. They take care of everything for you. The nice thing with that is that you get the peace of mind of knowing that an attorney's gonna handle everything for you. The downside is that the average divorce in this country costs each side $20,000, and if you're faced with the decision of, do I spend my child's college fund on an attorney, or am I a smart, capable person who can do a lot of this on my own? Then maybe that's the best bet for you. This is an analysis that you need to make, but I really strongly suggest that you really consider what the plan is. Don't go into this blindly, don't stumble along your path, really figure out what you are going to do. Step 3. The initial legal filings. Now we're going to walk through what to expect when you get into the actual case, and we will use legal decision-making and child custody As our example, as we walk through the process of what to expect when you're in a family court case. The first step is your initial filings, and your initial filings include the petition, the response, and potentially a motion for temporary orders. When you file a petition, or if you have been served with a petition, you're going to make a statement on how you want everything, what you would like to see happen. You're going to let the judge know what the potential issues are and how you would like the judge to resolve those issues. Unless you think that you are going to go through a default, and we'll talk about default. Consider keeping the statements that you make in the petition and in the response open so that, as you get more information, you can change and refine and really hone down and specify your position. In the 9 to 12-month process that you go through, typically, to get a divorce or go through a case, you may change your mind on whether or not you want to live in the house or sell the house. You don't want to lock yourself down to a position now because the risk is that an attorney could come in and say, Your Honor, I would like attorney's fees be awarded to me from the opposing party because they have been all over the place on their positions. They said this in the petition, this in their motion for temporary orders, they said something else in their resolution statements. Now in their pretrial statements they are asking for something they've never asked before, and therefore we should award attorney's fees, and I have seen this happen. In order to avoid that, consider keeping your options open early on. If you are the respondent, you've been served with a petition, what that means is that if you're in the state, you have 26 days to respond. If you're out of the state, you have 30 days to respond, and there's a couple of ways that you can draft your response. Many attorneys, many people, draft a response by admitting or denying the petition in each paragraph. So the response would be as so and so asks for sole legal decision making in their position, and you're going to say, I disagree with petitioner's position. I would recommend that you consider drafting your response more like a counter-petition where you affirmatively state what it is that you want. The motion for temporary orders will let you get in front of the judge, usually between 30 and 60 days after you filed a motion, to deal with imminent issues. With that being said, I should take a step back. Remember how we started with the importance of figuring out your objectives and really taking your time before you filed your documents, before you embarked on this decision. That does not apply if you are in a dangerous situation or if your children are in a dangerous situation. If you and your children are not safe, then you don't have time to come up with a strategy right now today. You don't have time to wait and think about how really you want your life to look in 3 years. Let's get you safe first and foremost. Then we will work on our plan, and that also ties into what we are talking about here at the motion for temporary orders. An emergency order is separate from a motion for temporary orders. An emergency order can be filed, let's say for sole legal decision-making if your child is in a dangerous situation, without an order in place. So that will not take you 30 to 60 days to get in front of the judge, that will be an immediate order. You go before the judge, it's called ex parte, it means that it's you, without the opposing party, and you are asking the judge for an emergency order, because if that emergency order is not going granted, there will be irreparable harm. It's something to consider, it's something that it's available to you. But the motion for temporary orders is not for those situations, it's not for an emergency situation. It's for situations where you need to figure out, during the pendency of your hearing, what the parenting plans are going to be, or you need temporary child support and you can't wait 12 months until the judge takes the final decision on child support, or you need temporary spousal maintenance, or you need to know who's going to pay the bills, or maybe you want to put the house on the market. There are really an unlimited amount of things that you can ask for in your motion for temporary orders, so consider whether or not that is something that you need. You can find all of these documents for free at the Maricopa County Self-Help Center. There are filing fees that are required for both petitioners and respondents. If you are unable to pay that filing fee, you can ask the court to defer that filing fee. That's something to keep in mind. You shouldn't let the inability to pay the filing fee stop you from filing.